Hi, I'm Attorney Jay Farrow, and I'm here to talk to you today about something I'm extremely passionate about. It's about innovating the law to make it more efficient, effective, and equitable. It's about revolutionizing the discovery process by utilizing social media to obtain information, witnesses that would otherwise go unnoticed or unheard. So this segment is about using what I call notice to witnesses in both written form and video form for the specific purpose of identifying whistleblowers to allow them to come forward to speak to myself or another attorney on a confidential basis. It's critical. And why is it critical? If you've been practicing law as long as I have, you know that the discovery process is a joke, or it's been made to be a joke by those with enough money and enough power to use the discovery process to outspend and outlast the other side. It's been going on for years. And I can't tell you how many cases that I'm involved with that I send out a request for production of documents or interrogatories, and I'm met with form objections. Just overly broad, harassing. It's the same thing over and over again. And then what happens is you have to wait like 3 months to get a hearing in some circumstances where the court will take an hour to hear what you have to say. And then maybe they'll produce some documents, maybe they'll produce some information. But it goes on and on and on. And how does that benefit the person that doesn't necessarily have the means to fund a wild goose chase of discovery objections? More often than not, their voices are silenced. So after thinking about this for a while and thinking about, well, if we're going to innovate the law, I mean, we got to bring it into the 21st century. And while the ability for a lawyer to research an issue has gone from 8 hours into a library into 5 seconds on one of the legal search engines, the law or court cases can take 3 to 5 years. Why is that? Well, it's because of this abuse of the court system. And that's exactly what it is. It's an abuse. It's abusive to the side that really has been victimized. Now, anybody can be victimized. And we represent a number of individuals who otherwise have means, but they were bullied in business as well. So what can we do? What can we do to find the information that nobody else can find? What can we do to find that witness that wouldn't necessarily come forward, but for an invitation to speak on a confidential basis? What we decided to do was to make press releases and notice to witness videos, both for the same purpose, is to draw attention to the case in order to have people to get engaged, and if they have information, to provide it to us on a confidential basis. Now, before we engage this process, obviously we had to look at the legal landscape and see, wait a second, you're about to use social media, Facebook, YouTube, and then news services to send out notice to witness press releases. What's the implication of all that? I mean, what's the law with respect to doing what's a discovery tool or an informal discovery tool as part of a lawyer's investigation? But what does the landscape look like? Well, there's 2 concepts that come up that we've researched, and one is called the litigation privilege, and the other is simply the First Amendment of the Constitution. Okay, so the litigation privilege. What is the litigation privilege? In its simplest form, is that anything that you say in court, in a court document, or relative to a court case, is absolutely privileged. What does that mean? It means that you shouldn't be ever sued for defamation or tortious interference for anything that you say in court. So there's this broad privilege, and if you use it, if you use the actual terms that you use in court, for example, I'm going to explain this a little bit better. You file a lawsuit, and the lawsuit has allegations, paragraphs 1 through 100. And some of those allegations, relate to specific information that one might prompt a witness to come forward. So if you're cutting and pasting from the complaint, this is exactly what we've done, is we cut and paste from the complaint, or we give a substantially accurate description of the lawsuit, the name of the parties, the claims that are in the case, and yes, quotations from the actual pleadings. And we, at the bottom of these press releases, have developed a paragraph that says that this is a notice to witnesses. In some circumstances, we say that the case hasn't been tried yet, the allegations haven't been determined. And if they have any information, if anybody has any information relative to the claims, contact us, and we're going to keep it on a confidential basis. We have, in our law practice, many cases that involve the Civil Remedies for Criminal Practices Act in Florida, or the federal, what's called civil racketeering statutes. Now, both of those statutes are very closely knit together. So I'm not saying that they're interchangeable, but in Florida, the civil racketeering statute, looks to federal law for interpretation. And in some of the cases that we have found throughout the country, especially in RICO, require that other victims or witnesses be found such that you're going to prove what's called a pattern of conduct or a regular way of doing business. Okay, and I'm making this sound like a no-brainer, right? Like you file a lawsuit for, let's say, a massive tort or massive fraud that involves a bunch of people, and you need some witnesses to come forward. All right, and then you create a press release that's based upon the pleadings, names of the parties, quotes from the complaints. In some of our cases, we do what's called notice to witness videos, and the videos identify myself, then the names of the parties, part of the allegations in the complaint. And then we ask people to come forward, either for reputation information or for the specific claims that are in the case. Now, it does sound like, wait, that sounds like that should all be covered by the litigation privilege. Well, in Florida, they have what's called a qualified privilege, which means that some out-of-court statements, if you're making them that are defamatory, you can get a lawsuit against you for defamation. But we were, in our research, and what I still believe is that anything that you say in court, if it's regurgitated some other place, the same protection should apply. Now, that's not just my belief, but we've done research for cases around the country. And we have found cases in New Mexico, in Texas, in California, in Washington State, and here in Florida, which specifically say that the allegations of a complaint and the names of the parties put into a press release are covered by litigation privilege. Why? Because it has some connection to the proceeding. There is not one outlying case that we have found at the appellate level that is adverse to this idea of using a press release to identify witnesses or find potential other victims in RICO cases that would support the claims. But here's the reality. The system, and by what I mean by the system, is that idea of that it's a automatic, where you have this discovery process, you send out the discovery, automatic objections, automatic frivolous objections, and then resolving that takes months and months and months of time. That is what they call the tried and true means of obtaining information in a lawsuit. Now, we have had multiple cases over the last couple of years where we've implemented these notice to witnesses, both video form as well as in press release form. And in each of the cases, we have had lawsuits filed against the law firm or our clients for defamation and tortious interference. And in at least 3 of these cases, the other party filed a motion for temporary injunction, saying that their reputation was destroyed, saying that this was a calculated effort to try to destroy their business by interfering with customers and the like. We've had 2 recent hearings where the judges absolutely expressed their displeasure with this practice. And I can understand. I'm not oblivious to what this feels like. Now, as a lawyer practicing for going on 18 years at the end of this month here in Florida, and since 2005 in New York, I understand that when you're doing something new and novel and you're putting yourself out there, and it's not something that judges are used to, there's going to be a visceral emotional reaction to this, and I can understand that. But what we're doing here is we're balancing, right? We're balancing interests in a lawsuit. Here, my clients, for instance, in the aggregate, have been ripped off for millions of dollars. Millions of dollars. They have a right to investigate their claims. What the other side is saying is that what you're doing, the way that you're investigating it, is not tried and true, and it shouldn't be allowed. Now, mind you, each case has been different, and I can caution you that there are some things that we would do differently. There's some things that we would do the same. Each case is different. But the actual act of posting a single press release or multiple press releases related to finding witnesses, or making these videos, it was like a 1-minute video searching for witnesses. Just that act of posting it, okay, is also covered not just by the litigation privilege, but by the First Amendment of the Constitution. And there's case law here in Florida that goes as far to say and talk about angry blogs and one case called Jilted Lovers. They talk about all of this stuff online, and all these things are posts. And what it is, and this is what the case says, is that these posts are the modern day picket sign in front of a car dealership saying, "Lemons sold here by these crooks." And what the case says is that, any consumer is not going to just make up their mind based upon a picket sign. They're going to make up their mind based upon their own research and due diligence. But the First Amendment is very, very powerful. And so when in our last iteration of a hearing on a motion for temporary restraining order, notwithstanding whatever the court said, there's certain things that the court identified that it probably couldn't do. And that is to stop the posting of what she called accurate descriptions of the lawsuit. What seems to me to be the most frustrating part about this is that the law seemingly is so clear that this evolution shouldn't have the pushback that it does. But the practical issue is that when you see something now on YouTube, and now you go onto Google and everybody can see it, that hasn't caught up with us. There's the power of the internet, the power of image, the power of the actual post hasn't really caught up to the judiciary or the other side. Even though, as a matter of law, and as has been in some of these cases written, it's no different than just picketing. It's no different than just holding up a sign and saying your piece. So at the end of the day, while some courts say that the litigation privilege is not going to apply here because these are statements that are made outside of the courtroom, we'll get to that on appeal. One of the cases in Texas talks specifically about that and said it would be illogical to hold somebody liable for defamation or tortious interference or other tortious conduct for statements that were actually already made in court and just regurgitated. Because why? Because anybody with a computer and a mouse can go to any clerk's website now and pick off any complaint. Why? Because we have something called electronic filing. So everything's in the court file anyway. So in some circumstances, this work is supplemental to other people's due diligence. Because let's not forget, once the lawsuit's filed, it's a publicly filed document. Okay, it doesn't go away. There's no under some circumstances maybe, but there's just no expungement of it. It's not going to go away. But I want to say this. In each instance that we have issued a press release or a notice to witness about a case, whether it was the generation of, because it was 3 of them or there's 4 of them, witnesses have come forward. And those witnesses have told us stories about their experiences with these various defendants. And in each instance, you hear some of the same: I would do something, but I'm afraid. I would do something, but I'm afraid they will financially ruin me. Some cases, they've even threatened to financially ruin anybody that would dare go against them. You hear these stories and you realize something, sitting in my chair, is that there's so many silenced voices out there with stories to tell as to civil lawsuits. And we see it every day. The police say something about a criminal thing and that we're looking for this person and they're alleged to have done A, B, and C, And it's time for the civil arena to catch up to that, especially when you're dealing with fraud cases where there's other potential witnesses and victims, especially in civil racketeering cases, where even some of the cases that are out there require that multiple victims be identified. And not to say that you're going to represent these other victims, because the key is you represent one client, you represent your client. And then in order to serve that client, even if you find other victims, they're not the client. They're going to be the witness. But without a means to see and hear about a case, I'm telling you right now, while these cases are public, CNN does not pick up on 99.99% of the cases out there. There are stories to be told with respect to these cases. There's justice to be had. I mean, could you imagine? Like if this was the norm, where once a lawsuit's filed, someone could go out onto, Facebook and YouTube and try to identify some witnesses. It could be even in the arena of personal injury, where, hey, did anybody see an accident, on the corner of Maple Street and Main Street on this particular day? You may catch somebody that would never have been found in regular discovery. So these conversations that we're starting today, I mean, I posted an article on my website. It's just to open the conversation, to ask other lawyers to join me in attempting to use press releases and social media to locate witnesses, to advance your client's claims, to give a voice to the unheard, and to truly equal the playing field. Because the other side of this is that, people with money, large corporations, they have their own means to silence people. And that's just obstructing discovery, standing in the way, and using their tried and true methods to end justice for many people. So I hope this has been informative. If you have any questions, you can reach out to me at info@farrowlawfirm.com or reach out to us on Facebook at the Farrow Law Firm. And I look forward to speaking to many of you. Some of you have already contacted me, and I look forward to creating this conversation because it needs to be had. It's time. And thank you for your time.